You're an AOR client, you've just been in a shooting. What do? What happens when you pick up the phone? When you call our law firm on that emergency hotline, the strike force is going to take action. Stay tuned. Hey everybody, this is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners of the Attorneys for Freedom Law Firm here today to talk about what happens when you're in an emergency situation. You got to call our 24-hour hotline. How's it going, Marc?
Great, man. I'm excited about making this video because this is a really common question that we get, which is, hey, I'm an AOR member. I call the emergency hotline. I'm in another state. What happens? And that's what this video is about.
I'm excited, too, because this is one of the things that really sets our program apart from all of the other insurance-based competitors, is they don't have a law firm ready to go, right? You may be able to call one of these clubs and talk to a representative of the club or maybe even somebody from the insurance company, who knows. But most of the time, you're not talking to an actual lawyer who can get things moving in your case right away and who is actually licensed to give you applicable legal advice on how to deal with that situation.
Yeah, I think the first place to start is thinking through the problem, right? I remember when I was a young lawyer, one of the more senior lawyers said, Marc, you're going to be a good lawyer someday, but you don't think three-dimensionally. And the reason, is you haven't had a bunch of trials. You haven't thought through the situation. How many release hearings have we done at this firm over the time, even in the years you've been practicing? Just countless numbers of release hearings. So we know already in that emergency situation what kind of information we need. Why wait until the emergency situation arises?
That's right. So step one to this whole process, really the ball is in our client's court. We've set up something on your online portal of information that you can fill out for us that's going to give us lots of great stuff that we need to make sure that we can most effectively spring into action if you ever have to discharge your firearm.
Yeah, we have a very detailed questionnaire. It's going to involve all kinds of important questions for AOR members to fill out at their leisure, right? Before the pressure's on, before there's an emergency, the kinds of information that we or a local attorney is going to need in that very first hearing, right? Imagine an incident's occurred, the police have arrived, they arrested you, they brought you downtown. You're going to be facing a judge for that very important first hearing where that judge is going to set release conditions. The issue is going to be, are you a danger to the community? Are you a flight risk? Those kinds of things. What's your past criminal history look like? Do you have access to firearms? We know these kinds of questions. There'll be a very detailed questionnaire that's going to go over in detail these kinds of questions, your ties to the community, who you've got as a potential third-party custodian, questions about people we could talk to, right? Because if you're in jail, you can't really take action, do things that you might need to do. Who can we call and talk to? Do we have permission to talk to them about the case? And also some other things we'd like to know, like do you have a preference for who local counsel should be, right? You may say, hey, I'm in Massachusetts, say where I'm from, and there's a local lawyer there who you really like. Put that on the form. That's going to be our first call out there in terms of getting a local attorney on board. So step one, if you're an AOR member, get into your portal, check out that very detailed form, and at your leisure, fill that out. Answer every question on there, and then upload that form back to your portal. So in an emergency, we've got that information.
Yeah, just to be clear, it's not mandatory that you fill out the questionnaire. We just obviously know it's in your best interest to do so. If you say, Marc and Andy, that sounds like a lot of work. I don't want to go in and fill out the detailed questionnaire. That's fine. You're only hurting yourself if you get into a situation where we need that information very quickly to do a release hearing. In fact, if you decide not to fill out the information on the portal, that's pretty much just the status quo like any one of these other competing insurance-backed self-defense programs. But that's something really special about our program that you can arm your lawyer with before we're in front of a judge trying to make the argument to get you out of a cage.
It's good to know who your lawyer is in advance so we can be prepared to deal with the case. Okay, so you call that emergency hotline, and regardless of when you call, 24/7, 365, 2 o'clock in the morning, Christmas Day, New Year's Day, whatever, you are going to be routed. If you call and say, I got an emergency, it's a self-defense incident, I'm an AOR member, I got an emergency, you are very quickly going to find yourself on the phone with an attorney from our law firm. It's very likely going to be me or you.
That's right.
Right, because we're the top 2 lawyers on that list because we want to take those calls. We love this stuff. This is what we do. But if for some reason I'm not available, you're not available, we have many other criminal defense lawyers at our firm with experience who know how to handle these calls, who we've met with in advance and prepped and are ready to deal with that call. You should expect one of the first questions is going to be, hey, can we have a private conversation, right? Because sometimes the police are standing, sometimes there are other people standing around. We're going to want to know what the situation is at the scene. We're going to want to know if human life is in jeopardy. If so, we got to get somebody, probably not the person who's the client, to call 911 and make a very brief statement. There's been a shooting. We need medical attention. Here's the address. Goodbye. And then we're going to give the advice to not make any statements. If the police are there, we're going to ask to speak to the police. They may or may not speak to us. I've had this situation on countless occasions. Most of the time they will, and we can get some information from them. And then we can do our best to put the facts in the best light. So maybe we can avoid an arrest.
Yeah, as somebody who's taken a number of these calls at 2:30 or 3 a.m. When the client has just been involved in this type of an incident.
We just had one this past weekend.
We just had one. I was just thinking about the one we just had this last weekend. But usually the client is either in total and complete shock or very elevated at the time. And so just having an attorney on the line to help you remember what to do is helpful. Like, for example, sometimes you got to tell a client, now the police are on the way. Set the gun down. Don't hold the gun. Or don't tamper with this part of the scene, or put this here, put this there. This is what to do. This is what to say. This is not what to say. We all like to think that if we were in an extreme situation like this, we would know exactly how to act. But it is invaluable to many of our clients that we've heard from over the year that, guys, I'm so happy you were on the line walking me through what to do at the time, because I never thought I would feel the way that I did in that moment.
The call we had this weekend was exactly that. The person on the other end of the line just needed some advice.
That's right.
Couldn't think clearly at that point, and it was a good thing.
Understandably.
Yeah, understandably. All right, so that's going to happen. We're going to dispatch advice right then and there. If you're an AOR member, you got an emergency, you will be speaking to a criminal defense lawyer at our law firm.
And just to throw something else back to point number 1 about that questionnaire that we're asking you guys to fill out for your own good. Do you really want to be recounting all of that information about yourself? Are you even capable of recounting all of that important information about yourself and your situation and your employment history and your living arrangements and your history in the community? In that moment, right after you've discharged your firearm in a self-defense shooting, you may not even be capable of thinking straightly about all that stuff. It's just super important to get that stuff. Be proactive. Get it done ahead of time.
We don't want to be doing an interview right then and there, right? But also, you may only get 30 seconds. I've had calls where people have called me, and then the police officer, you hear in the background, put the phone down, you're under arrest.
You're under arrest.
But I'm talking to my lawyer. Put the phone down, you're under arrest. You know, so you get stuff like that, too. You may not have time to have a full discussion. We got to have that information so we can move. Okay, next call is going to be to the strike force. What the heck is the strike force, Andy?
The strike force is the team at this law firm that we have rearing and ready to go in just this type of an event.
Yeah, so we have assembled a team at our firm of paralegals who are experienced and other players at our firm who know exactly what the drill is. And so there's a team that will be working on the local attorney. They know exactly what we're looking for. Should be no surprise to anybody. We want an experienced criminal defense lawyer who is pro-Second Amendment, pro-firearms, understands the law of self-defense, and enjoys it like we do, and preferably who's pro-freedom and who could bring something to the case. We got to have a local attorney if it's an out-of-state case so we can be admitted pro hoc vice. If we're going to bring someone on board, we want the best possible attorney we can get a hold of. This is why, if you got someone you like, you put that person on that form.
Right.
We pull that form, and boom, that'll be our first call to your selected local attorney. But we want to get somebody on board. We're ready to go. We know how to pay that person. We get them the pro hoc vice fee agreement between the two law firms. We can get everything done. We can actually give them the form that they need if we can't get out there for that first hearing, so they can make that argument to the court, so people in AOR will have the very best representation at that first hearing.
That's right. Just to be clear, maybe you don't know a local attorney. Many people don't ever deal with attorneys and have no idea idea where to start when it comes to picking a good one, no problem. We know exactly what we're looking for. We're going to research who's the best attorney. If you don't have a preference for local counsel, we're going to find them by all those criteria that Marc just listed out, and we're going to find the best fit for the case, and we're going to get somebody who's going to bring something to the defense team here, not just somebody who's a warm body, preferably.
And there are networks across the nation of very qualified...
that both of us belong to.
That's right. And so it's very easy for us to get them on the horn immediately, get them the form, consult with them, and make sure we can get good, solid representation wherever the client is.
Yeah, what are we prepping up for here in the beginning? It's this thing that we're talking about, the initial appearance that happens usually at the jail, at a court that's located in a jail.
Right.
And different states have different rules about when and where these hearings will be set, but many states, for example, have a 24-hour period that they have, that once the police snatch you, once they make a seizure of your person pursuant to the 4th Amendment of the United States Constitution, we say, hey, that's a really big deal. So we want you to move fast, law enforcement, and so we give them 24 hours to place your body in front of a judge who can then set your release conditions. That's when we shine.
Yeah.
Because that's when we're getting the local counsel. That's when we're grabbing all of your information that you've hopefully provided us in the questionnaire. That's when we get prepared to make our argument for a release, maybe an OR release or a nominal bond or some sort of supervision, so that you're not sitting in a cage thumbing through the yellow pages trying to figure out how you're going to get out and defend this case.
Yeah, and many of the big metropolitan cities run these hearings around the clock, right? So they do them maybe every 4 hours. Also,
we've been to a bunch of these over the years.
We call them...
I named these things.
Yes, you did.
I like to call them late-night freedom fights.
We love the late-night freedom
fight. 11 p.m., the 1 a.m., the 3 a.m. Love these things.
I've been there every hour on many occasions. And also, there's a few little tricks of the trade, right? So if we're heading down there and there's a hearing about ready to happen, and we can often call that court and say, hey, bump it to the next one in 4 hours so we can make sure we're prepared. The ideal situation is for the lawyer to go down to the jail, to actually meet with the person before the hearing, to reassure that person, to tell them we got the information, maybe to go over the information on the form, make sure it's current. You also want a little bit of time to work that prosecutor, right? Because if the form was filled out, we probably have a pretty good idea what amount of bond can be posted. And say, for example, we know that $75,000 is the biggest bond that can possibly be posted here, given everything we know. And the prosecutor is at $100,000, and we say, okay, how about 50? And they say, well, something in the middle. How about 75? And if we can make an agreement to something that we know in advance, the client
is doable
can
for the
yes,
client, right?
We can make that happen. I've often, on many occasions, I know you have as well, not only met with the prosecutor before the hearing, but also the judge.
The judge, yeah.
Yeah, there's usually a form that the police officer will fill out that they give preliminary information to the judge. We can get a copy of that as well. And many, many times you can work something out back in chambers.
That's right.
Before that hearing even. You already won the hearing before the hearing starts.
That's right.
So we like to have enough time to give us every possible advantage to make that happen. These are the kinds of things insurance companies don't know because they don't do this. But criminal defense lawyers who don't just comment about self-defense online, but actually go to court on a regular basis and fight these cases in the trenches, the kind of stuff we know about.
Continuing on with the strike force's duties, we've now gotten on the other side of that initial appearance. We've now fought to get our client out of custody, and now at this point we move to get admitted pro hoc vice in your state. So we've been able to advise you, give you basic advice up until this point, even though we're not admitted in pro hoc vice in your state at this step, because there's certain ethical rules governing all 50 states saying that we can give emergency advice and exactly this type of thing, even though we're not admitted yet.
That's a good point. Yes, so you said it exactly correctly. Even though we're not admitted in an emergency situation like this, we can still give advice, no problem. So then the portion of the strike force that deals with the pro hoc vice, that part of the team is now in place. We have the rules for pro hoc vice admission in all 50 states. We know exactly what is needed in every state. We have those documents ready to go. Sometimes it requires us to continually send in to get a certificate of good standing from either the Supreme Court or the state bar every 30 days. States like New York are a real pain in the neck.
And so just to be preemptive on that,
Yes.
we make a regular business practice of constantly getting, just as a routine, we have our certificates of good standing ready to go so that we don't have to wait around for a couple of weeks in order to get those.
That's
so they're
right.
ready to file right
We don't
away.
want any delay. We also have the motion drafted for the local attorney to file. So we give the local attorney the fee. There's always a fee. The government doesn't do anything without a fee. The motion to file, which they may or may not need to tweak a little bit pursuant to the local rules, and then whatever documents they need so they can file that document to get us admitted pro hoc vice. I should say we have never been even once denied a pro hoc vice admission. We have at almost all times in the last 27 years since we've had our firm operating, at least one case in another state. We have multiple cases in other states right now. Never had a problem with it. In fact, in our fee agreement in that section, we note the Supreme Court case that dealt with the Sixth Amendment right on pro hoc vice. I think it would suffice to say the Supreme Court has recognized under the Sixth Amendment, you got a right to the counsel of your choice. And the local court can't just say, sorry, we only favor local attorneys. We're not going to let these out-of-state lawyers in pro hoc vice. To be fair, we really don't need a lot of help from the local attorney, but there are some things, right? We want a local attorney who maybe can tell us a little bit about the judge. What's this judge like? Maybe the prosecutor. Sometimes there's some language that's a little different from state to state.
Local procedural rules, how to file things in this particular court, things like that. But self-defense law is pretty universal across all of the 50 states that we've had cases in. And so it's not the type of thing where we need somebody to help us reinvent the wheel.
I mean, there's differences, but it's very easy to ferret those out, right?
The requirements of imminency and
that's all
proportionality and generally the same types of exceptions and everything.
That's very similar.
It's all uniform.
But there are little nuances that are different, but this is not a problem. We pull up the statute in 5 minutes, review that. We can also pull the jury instructions. We would do this if it was an Arizona case. In every case, we do the same thing. We pull the statute, we review them, we pull the jury instructions. We will be very well versed in exactly what the elements are of the crime that is charged and as well as what we need to show for self-defense. Some states, we've got the burden. Some states, the state has the burden to prove that it wasn't self-defense. That's not a problem. So very easy for our strike force to get us involved in the case. It'll probably take a few days, maybe a week, and then boom, we'll be admitted. We don't want to promise people that they're going to get 2 lawyers, but they might, because we're both interested in doing these cases.
Yeah, and you and I regularly travel to different states to do different cases at any rate, because we like it, because we actually enjoy what we do. So continuing along with the duties of the strike force here, there are some times that there's some other urgent things that need to be taken care of that are also covered by the AOR plan. Like, for example, maybe in the shooting there was damage to your property or there needs to be scene cleanup. These can be messy situations sometimes. There can be just property damage, a bullet hole in the wall, whatever, the carpet stain, whatever it may be. And we know that our clients wouldn't want to be in that environment for 1 minute longer than they have to. So that's part of the duties of our strike force as well.
After the scene is processed, right?
That's right. That's right.
After the scene is
after the evidence all collected and everything like that, we'll send in a crew to clean everything up. We'll also take care of things like if there's urgent mental health counseling that needs to be rendered. I understand completely that when people go through these traumatic events, oftentimes they don't want to wait around in order to receive help for what they're going through.
The strike force has those duties. Also, we should mention that on that form, if you have a preference for a bondsman, that will be on there. So if you say, hey, look, there's a bondsman out there, I like this particular bondsman, a part of the duties of the strike force, if a bond is needed to be put up, then we will make that happen. And so they know exactly to check the form. If we don't have a bondsman there, then we'll find a local bondsman, someone we can work with and get that process done efficiently. Because look, if people are in custody, we know what they want at that point is to get the heck out of custody.
That's right. So now we're past all of the urgent stuff that the strike force handles, and now you're in the very capable hands of your legal team. At this point, we're now admitted pro hoc vice. You're hopefully out of custody. If everything goes well, then we're now well on our way in order to defend you in the case. We're getting the evidence, and we're moving forward from there.
Yeah, I should also mention the strike force has the responsibility of having a communications team as well, because if you get arrested and taken away, there's going to be probably somebody who loves you or maybe likes you a lot, who's interested in your welfare. We want to make sure that the communication is easy, no matter what time of day it is, and someone on the strike force will, along with a lawyer, be taking the lead on the communications team. Here's what's going on. Here's what we're doing. Here's what we expect next. Here's the local attorney. Do you have a bondsman? Here's what we've done with the bondsman. Do you have these other needs, things that you have talked about? So there will be excellent communication between the AOR member, who is a client of our firm, and the firm, as there is in all cases at our firm.
Yeah, oftentimes there's legal purposes for us to have good communication with your loved ones or people who you've listed on that contacts form. For example, sometimes the court, before releasing somebody, wants to know that they're going to a secure location or a good home or something like that. And so we may actually have to bring somebody in to vouch for that person. Yep. or something like that, vouch for their character, vouch for their employment, things of that nature as part of getting them released. So very, very important to give us that information as well.
So bottom line, this isn't our first rodeo. I've been practicing 30 years. Our law firm, the Attorneys for Freedom, has been in business 27 years. And for each of those years, and at all times, we've been handling major felonies and many matters out of state. So it's not our first rodeo. We know exactly what to do, and we have thought it through very carefully. Look, nothing's going to go perfect. Every case is different. There could be hiccups along the way, but we'll deal with them and address them in a professional, competent, urgent kind of a manner. So that's what happens when you call the emergency line when you're an AOR member. We jump into action immediately, and we will assume that you're on the right side of the issue. We will assume, you're presumed innocent, and we will start marching immediately under the assumption that this is a matter that checks all three boxes.
Yeah,
right?
That's right. The reason why we created this strike force, and we spent a lot of time thinking about it, had multiple meetings where we made sure that everybody had their tasks assigned and that there was an understudy and maybe an understudy for the understudy for each role of every single one of these gears in the machine, is totally based on just listening to the people's ideal programs.
Yep.
Right? A big gripe about all these other programs is often, what do? I just called how do I talk to a lawyer? I'm just calling the program. I'm calling the club. Am I getting an insurance guy on the other side? And so just listening to people, it was really important to people with their program, their ideal program, that if they were ever involved in this type of an incident and they had to discharge their firearm in self-defense, they know they're going to be able to get an attorney on the line promptly.
Yeah, I think it's important to mention, because people sometimes say, wait, you got to be charged with a felony. You may not be formally charged with a felony for quite a while after that self-defense incident. Our fee agreement says charged with a felony or reasonably expects to be charged with a felony. That's what covers you from that very first call. We know you're not charged with a felony right after the shooting, right? You can't be charged with a felony that quickly. Many times a prosecutor's going to have to review that case and file a formal complaint or take it to a grand jury. That takes time. So we don't wait for that, right? If you're an AOR member and you call and say, hey, I've been in a self-defense incident, we're going to jump on that immediately.
That's right. All right, everybody, that's how the strike force works. You can go to attorneysonretainer.us to learn all about the strike force and the wonderful AOR program and how it can help you with peace of mind in case you are ever involved in an incident like this. We've got your back, and you can rest assured of that. You can also go and check out attorneysforfreedom.com to learn more about our law firm. And until next time, my friend, this has been Attorney Andy Marcantel and Attorney Marc J. Victor.
Peace.